Guilty on all counts. Donald J. Trump, the 45th president of the United States, was found guilty late today in a New York courthouse on all 34 counts of falsifying business records to conceal payments to a porn star just before the 2016 election. The stunning verdict was delivered by a Manhattan jury of 7 men and 5 women who deliberated for 2 days, making Mr. Trump the first former American president to be convicted of a crime. He remains the presumptive Republican nominee in the close race for president. Mr. Trump stood in the courtroom in Lower Manhattan as each of the jurors confirmed they agreed with the verdict. Afterward, Mr. Trump called it a disgraceful trial and still claimed he didn't do a thing wrong. In a statement, President Biden's campaign said, "In New York today, we saw that no one is above the law," adding that Donald Trump has always mistakenly believed he would never face consequences for breaking the law for his own personal gain. Today's conviction will no doubt have an impact one way or another on this year's election.
It's John and I have been thinking about this all week. On the 30th of May 2024, a Manhattan jury found Trump guilty on all 34 felony counts, unanimous on every charge. The verdict, delivered after 5 weeks of testimony, marked the first time a former U.S. president had been convicted of a crime. And the word guilty cannot be unsaid. The core of this story is something that every American needs to understand before we go any deeper. A Manhattan jury convicted Trump on all 34 felony counts of falsifying business records. The charges were connected to reimbursements that the Trump Organization paid to Michael Cohen, Trump's longtime personal lawyer and fixer, after Cohen had wired $130,000 to adult film actress Stormy Daniels just days before the 2016 presidential election.
We have it all covered for you on this historic night, beginning with senior legal correspondent Laura Jarrett. Laura, a truly historic day in court.
Indeed, Lester, one simple word, guilty, repeated over and over and over and over. 34 times, those simple words, something that happens every day in courtrooms across America. But this time was different. This time about the current presumptive GOP nominee, a former American president, something we've never seen before. Those ladies and gentlemen of the jury, 12 members from everyday walks of life in New York City. We had a salesman, the foreman. We had 2 lawyers. We had someone who was a physical therapist, a speech therapist, all walks of life coming together for a unanimous verdict today, Lester.
This all occurred when we thought that the jury was about to retire for the evening and come back tomorrow. The court very much caught off guard, it appeared.
Lester, it had, because we were really not certain that we would see a verdict at all. The judge obviously wanted to accommodate that schedule, to do as much as they could. Here's our story.
The purpose of that payment was to keep Daniels from publicly discussing an alleged sexual encounter with Trump, which Trump has always denied happened. Cohen testified that Trump had directed him to make the payment, that they had discussed it beforehand, and that the entire arrangement was designed to prevent a damaging story from breaking in the final weeks of a presidential campaign. Trump's legal team attacked Cohen's credibility relentlessly, pointing out that Cohen had been convicted of multiple federal crimes, had lied to Congress, had gone to prison, and had since written a book publicly attacking Trump. And they were not wrong that Cohen was a deeply flawed witness. But here's the key criminal element that most people get confused about when they try to understand this case.
Tonight, former President Donald Trump found guilty, convicted by a Manhattan jury of all charges. Now the first American president ever convicted of a crime. Jurors finding Mr. Trump guilty on all 34 counts of falsifying his business records to cover up a conspiracy to influence the 2016 election by hiding how he reimbursed his former fixer for paying off a porn star before the election. The Manhattan jury of 7 men and 5 women included 2 lawyers, 2 in finance, and the foreman in sales, and reached their decision after 2 days of deliberations, after hearing from more than 20 witnesses over 6 weeks. The prosecution's case largely came down to whether jurors would believe the word of Michael Cohen, Mr. Trump's former attorney and self-described fixer. Cohen was the only witness who directly tied Mr. Trump to the alleged crime of falsifying business records. He testified Mr. Trump directed him to pay off Stormy Daniels so she couldn't derail his campaign. She'd alleged a sexual encounter years before, but Mr. Trump vehemently denied it. Prosecutors argued at trial the former president was desperate to keep her silent.
The crime was not the payment to Stormy Daniels itself. The crime was how the reimbursements to Cohen were recorded afterward in the Trump Organization's official business books. The Trump Organization logged those payments to Cohen as legal fees month after month through 2017, with invoices for legal services that were never actually performed. Prosecutors argued those records were falsified deliberately to disguise what was really happening and to conceal what they characterized as an illegal campaign contribution to Trump's 2016 presidential campaign. Since the purpose of the payment was to benefit the campaign by suppressing a damaging story, the jury agreed with that framing, all 34 counts. Unanimous, in less than 12 hours of deliberations. That is not the kind of outcome that reflects a close or disputed evidentiary record.
Panicked after the release of the Access Hollywood tape and then covered it all up, approving a scheme to disguise the $130,000 payoff with a phony paper trail through invoices, vouchers, and checks. Cohen's credibility in this case was key, the defense team branding the now disbarred lawyer who'd been convicted of lying under oath as the MVP of liars with an axe to grind against Mr. Trump, while prosecutors argued Mr. Trump chose Mr. Cohen for the same qualities that his attorneys now urge you to reject his testimony. Mr. Trump, who did not testify, reacting to the verdict tonight, attacking the case as politically motivated by a Democratic DA in deep blue Manhattan.
It's a rigged trial, a disgrace. They wouldn't give us a venue change. We were at 5% or 6% in this district, in this area. This was a rigged, disgraceful trial. The real verdict is going to be November 5th by the people, and they know what happened.
Outside of court, boos and cheers.
Late today, District Attorney Alvin Bragg reacting to the verdict.
We arrived at this trial.
The atmosphere inside that courtroom is part of the story, and it has mostly been reduced to a single headline in how people remember it. The trial had been running for 5 weeks, 31 witnesses, mountains of documents. The testimony of Stormy Daniels herself, describing the alleged encounter in graphic detail that prompted multiple mistrial motions from the defense, all of which were denied. The testimony of Michael Cohen, a convicted liar and admitted criminal who had every reason to be viewed skeptically, talking about the scheme he said he helped orchestrate. And through all of it, Trump sat at the defense table in his blue suit, sometimes appearing to fall asleep, sometimes shaking his head, sometimes whispering to his lawyers. His team attacked every witness. They made the case about Cohen's credibility.
And ultimately today at this verdict, in the same manner as every other case that comes through the courtroom doors, by following the facts and the law.
All right, Laura, we heard quite a reaction, I recall, when you were reading that verdict from the crowd. But what happens next in terms of sentencing?
Lester, now this case will proceed to sentencing. Both sides will have an opportunity to tell Judge Merchan what they think is an appropriate sentence. He faces anywhere from just probation to up to 4 years in prison, maximum on that. It's completely within the judge's discretion, and he will do that sentencing right here on July 11th, Lester.
All right, Laura Jarrett leading us off with the breaking news, and NBC's Peter Alexander has been following it all from Washington. Peter, any reaction from the White House or the Biden campaign tonight?
Yeah, Lester, to be clear, we don't expect to hear from President Biden about Mr. Trump's conviction tonight. He is in Delaware with his family on the anniversary of his son Beau's death. The Biden campaign, though, they did put out a statement saying the conviction shows, quote, no one is above the law. It adds there was still only one way to keep Donald Trump out of the Oval Office.
They argued the legal theory was novel and convoluted, and the whole prosecution was political. And then the jury went away, and the waiting started. On the afternoon of May 30th, the note came. Verdict reached. 1 hour later, the foreperson stood up and said guilty, and then said it again and again, 34 times total. The room went silent. A former president of the United States, a man who had just won his party's presidential nomination, a man who would soon begin his second term at the White House, convicted of 34 felony crimes by 12 ordinary American citizens. That is what happened in that courthouse. Trump walked outside and called it a rigged, disgraceful trial. He said the real verdict was going to come from the American people on Election Day. He said he had done nothing wrong. He said he was an innocent man. And then he went and raised millions of dollars in campaign donations in the 24 hours following his conviction because his team had set up a fundraising operation specifically designed to capitalize on the verdict. The story did not end with the guilty verdict. It continued through months of legal maneuvering and then landed on January 10th, 2025, 10 days before Trump's second inauguration, when he appeared on a video screen in a Manhattan courtroom to be sentenced as a convicted felon by the same judge who had presided over his trial. Between the guilty verdict in May 2024 and the sentencing in January 2025, there is a full story that most people only caught pieces of. Understanding the whole arc, the verdict, the aftermath, the legal battles over sentencing, and then what Judge Merchan actually said when he handed down the sentence is what makes this story genuinely historic rather than just politically dramatic. Start with the trial itself and why the jury came back so quickly and so decisively. The deliberations lasted less than 12 hours total, beginning on a Wednesday morning and delivering the verdict just after 5 o'clock on Thursday afternoon. For a trial that ran 5 weeks and involved 34 separate counts, 12 hours is an extremely short deliberation time. Legal observers noted that the speed strongly suggested the jury found the documentary evidence, the physical paper trail of documents, straightforward and compelling, even if individual witnesses like Cohen were viewed with some skepticism. That paper trail was always the real heart of the prosecution's case. Ledgers showing the payments to Cohen recorded month by month as legal fees under a retainer agreement. Invoices Cohen submitted to the Trump Organization for legal services that were never actually rendered. Checks signed by Trump himself reimbursing Cohen over the course of 2017. Internal notes and communications connecting the reimbursement structure all the way back to the original hush money deal with Stormy Daniels. All of it together created a picture of a carefully constructed paper scheme built inside a real company's official business records, designed to make a politically sensitive election-related payment look like ordinary, routine legal business activity. 12 jurors looked at that paper trail alongside the testimony of witnesses who corroborated the documents from multiple directions and concluded beyond a reasonable doubt on every single count that those records were falsified with intent to deceive. 34 counts unanimous. That level of unanimity across that many counts and that short of deliberation time tells you something very specific. The jury did not have much to argue about once they got behind that closed door. The documents said what they said, and the documents told a story that 12 people found convincing beyond a reasonable doubt. Now let's talk about what happened in the months between the verdict and the sentencing. Trump's legal team threw everything they had at trying to delay or prevent sentencing from happening at all. They argued the Supreme Court's summer 2024 ruling on presidential immunity should apply to evidence that had been used at trial. They argued that the judge should have recused himself due to alleged conflicts of interest involving his family members. They argued the case should be transferred to federal court. They asked the state appeals court to step in and block sentencing. They went to the United States Supreme Court and asked the justices to block the sentencing proceeding. The Supreme Court declined in a 5-4 vote, allowing the sentencing to move forward. At every stage, when Trump's lawyers made their arguments directly to Judge Merchan, he responded in writing that the arguments repeated points that had been raised numerous times before, relied on legal authorities that were factually distinguishable from Trump's situation, or simply did not apply. Each attempt to delay got denied. Each emergency motion got rejected. On January 10th, 2025, with his inauguration 10 days away, Trump appeared on a video monitor at Manhattan criminal courts to be sentenced in a blue striped tie from what appeared to be Florida, looking directly into a camera, while a judge in New York read out the sentence that would make him the first convicted felon ever sworn in as President of the United States. The sentencing itself lasted less than 20 minutes. But the words Judge Merkin spoke before announcing the sentence are the part of the story that carries the most legal and historical weight, and they have been largely underreported relative to their significance. Before he said a word about the sentence, Merkin addressed the unique circumstances of the case directly and at length. He noted that never before in the history of that court had it been presented with such a unique and remarkable set of circumstances. He acknowledged that Trump was about to become president again in 10 days. He said he had thought carefully about what the appropriate sentence was, given everything that was in front of him. And then he said something that cuts right through every political argument surrounding this case and lands on the actual constitutional question. He said that the protections afforded to the office of the president apply to that office, not to the occupant of that office. Think about what that sentence means and why it matters. The presidency as an institution deserves respect and protection under the law. Merkin was acknowledging that and building his sentencing decision around it. But the man who holds that office does not get to use the institution as a retroactive personal shield against the legal consequences of what he did before or during his time in that office. The office is what is protected. The person who happens to hold it at any given moment is not automatically shielded from accountability for their own conduct. That distinction, the office versus the occupant, is now part of the official court record of this case. Merkin then sentenced Trump to an unconditional discharge on all 34 counts, meaning no jail time, no probation, no fines of any kind. But the conviction stands. The guilty verdict stands. The felony record stands. Trump walked out of that hearing 10 days from the White House as a convicted felon on 34 counts. And there was nothing he or anyone else could do to change the word on that court record. Let's be specific about what the unconditional discharge actually means and what it does not mean. There was immediate and widespread confusion about this after the sentencing, and some people deliberately misrepresented it. An unconditional discharge is not an exoneration. It is not a not guilty finding. It does not erase the conviction. What it means is that the court decided not to impose any additional punishment beyond the fact of the conviction itself. Merkin explained this reasoning at the sentencing. He said the only lawful sentence that does not encroach on the highest office of the land is an unconditional discharge. In other words, the judge was saying, I cannot send the incoming president to jail. I cannot put conditions on his freedom that would interfere with his ability to govern. But I can and will keep this conviction on the record as a permanent statement of what a jury found him guilty of. And that is exactly what happened. Multiple conservative politicians and commentators immediately claimed on social media that the unconditional discharge meant Trump had been totally exonerated. That claim was false. The conviction is real. The felony record is real. The word guilty said 34 times by 12 jurors is real. An unconditional discharge means the court chose not to impose punishment beyond the conviction. It does not mean the conviction did not happen. The fact that it had to be explained and debunked in real time says a lot about how this story has been processed. Trump's statement before receiving the sentence was everything you would expect and also genuinely revealing. He said it had been a very terrible experience. He said the case had been a political witch hunt brought to damage his reputation so he would lose the election, and obviously that did not work. He attacked an assistant district attorney by name. He blamed his accountants for how the payments to Cohen were logged. He claimed the district attorney had not wanted to bring the case. He said he had been treated very, very unfairly. He said he was totally innocent. Then Judge Merkin wished him Godspeed as he assumed his second term in office. And Trump logged off the video connection. It was over. 10 days later, Trump was sworn in as the 47th president of the United States, the first convicted felon to take the oath of office in American history. The prosecutor at the sentencing said something that deserves to be noted. He said Trump had caused enduring damage to the public perception of the criminal justice system through his relentless attacks on the judge, the witnesses, the prosecutors, and the institution itself throughout the case. That observation went mostly unremarked in the coverage, but it captures something real about what the post-verdict period looked like and what its long-term effects may be. The verdict itself was historic in a way that cannot be undone regardless of what happens next, legally or politically. May 30th, 2024, a 12-person jury in Manhattan. Less than 12 hours of deliberations across 2 days. 34 felony counts submitted to that jury by the prosecution, unanimous guilty on every single one. That verdict made Trump the first president in American history, sitting, former, or future, ever convicted of a crime in a court of law. No other president had ever faced a criminal jury. No other had been indicted on criminal charges and taken to trial. No other has stood in a courtroom while a foreperson read a verdict about them. This was the first time the American criminal justice system ran all the way through the process and produced a finding about a president's conduct. And the finding was guilty. Guilty on every count the prosecutors charged. The speed and the unanimity of that verdict carries independent meaning. It was not a hung jury. It was not a split result with some counts resolved and others in dispute. It was not a jury that took a week to reach a compromise on a complicated factual record. 12 people went into a room, looked at the documents, reviewed the testimony, and came back in less than 12 hours with guilty on all 34. That is the verdict. It now sits permanently in the public record of American legal history. It cannot be revised by a political rally. It cannot be reversed by a social media post. It cannot be amended by an election result. Whatever happens in any court going forward, that verdict happened on that day in that room. And it is part of what it means that this man has twice been president of the United States. The sentencing was a legal and institutional statement as important as the verdict itself. What Judge Mershon said before announcing the unconditional discharge was not just procedural preamble. It was a direct and deliberate statement about the limits of presidential power as it relates to criminal accountability. When he said the protections afforded to the presidency applied to the office and not to the occupant of that office, he was drawing a line that has enormous implications for how American law thinks about the relationship between executive power and criminal accountability. He was saying, I respect the institution of the presidency. I am not going to sentence the incoming president to jail or probation in a way that would disrupt his ability to govern. But I am also not going to pretend that the jury's verdict does not exist. I am not going to erase what 12 citizens found beyond a reasonable doubt. The office protects the institution. It does not give the person holding it a retroactive shield against what happened before they won the election. That distinction, the office versus the occupant, is now part of the official record of this case in the New York court system. The appeal does not change what has already happened and where things currently stand. Trump's legal team immediately signaled an appeal after the verdict and filed the formal brief in October 2025, a 96-page document arguing the trial was fatally marred by faulty evidence, that Judge Merchant should have recused himself due to alleged conflicts involving small political donations and family members' professional activities, that evidence protected by presidential immunity was improperly admitted at trial, and that the underlying legal theory connecting the falsified business records to election law violations was novel and constitutionally improper. The Manhattan DA's office pushed back on every single argument in the response brief, telling the appellate court that time had not improved the defense's arguments and that the record fully supported the conviction on every count. The appeal is currently working through the New York State appellate system. A federal judge also signaled skepticism when Trump's team tried to move the case to federal court to make immunity arguments in a different jurisdiction. Here is the critical thing that gets repeatedly misunderstood or deliberately misrepresented in how this case is covered. Until an appellate court issues a ruling that actually reverses or vacates the conviction, which has not happened, the conviction stands as the current legal reality. The guilty verdict is real. The 34 felony counts are on the record. The appeal is an argument that the guilty verdict should not have happened. But making that argument in a brief does not suspend the verdict while you wait for the answer. Trump is a convicted felon who is asking a higher court to undo the conviction. He is not a person who was found not guilty and is defending that finding. Those are fundamentally different legal postures. Whenever that appellate ruling eventually comes down, it is going to be one of the most significant moments of his presidency, regardless of which direction it goes. This verdict sits alongside everything else in a way that permanently changes the political and legal landscape, regardless of what comes next in any other case. The New York conviction was the only one of Trump's 4 criminal cases that actually went to trial and produced a jury verdict. The federal election interference case brought by special counsel Jack Smith was dropped after Trump won the 2024 election because Justice Department policy prohibits prosecuting a sitting president. Jack Smith's final report stated plainly that the evidence was sufficient to obtain and sustain a conviction at trial, but that DOJ policy required the cases to be dismissed once Trump became president-elect. The classified documents case was dismissed by federal judge Aileen Cannon before it ever reached trial, a ruling that was itself controversial and is still being discussed by legal experts. The Georgia election interference case is still technically active, but is moving through years of delay caused by a prosecutorial conflict of interest dispute. Of the 4 criminal cases that were brought against Trump, the only one that a jury ever got to hear was this one. The only verdict that exists, the only time 12 ordinary Americans were put in a room and asked to decide beyond a reasonable doubt whether Trump committed crimes, is the guilty verdict in Manhattan on 34 felony counts. That verdict now sits as the sole legal finding ever made by a jury about Donald Trump's criminal conduct. It is the only time the system ran all the way to the end, and the end was guilty on every count, unanimous, in less than 12 hours. That is the permanent historical record. No amount of political argument, no amount of fundraising, no amount of social media posting changes what 12 people decided in that room on May 30th, 2024. The appeal in New York is moving through the courts right now and will eventually produce a ruling that either upholds the conviction or overturns it. If the conviction is upheld on appeal, Trump will leave office at the end of his 2nd term as a man with a permanent felony record, having served as president with that record attached to his name for the entire duration. That is without precedent in American history. And it matters as a statement about what the legal system found about his conduct. If the conviction is overturned on appeal, the administration will claim total vindication and will use it aggressively to attack every institution and every person who was involved in bringing the case. Either outcome is going to reverberate across the political and legal landscape in significant ways. Beyond the appeal, the broader legal context has also shifted substantially. The federal election interference case was dropped when Trump won the election. The classified documents case was dismissed before trial. The Georgia case is buried in years of delay. The hush money case is the only one that produced a jury verdict. It is the only one that went all the way. The prosecutor said at sentencing that Trump had caused enduring damage to the public perception of the criminal justice system through his sustained attacks on the judge, the witnesses, the prosecutors, and the institutional legitimacy of the proceedings themselves. Whether that damage is permanent or reversible, and whether the appeal upholds or strikes the conviction will shape how American history eventually writes this chapter. Watch the appellate courts. Watch the timeline. The moment that ruling drops is going to be one of the biggest legal and political stories of this administration. This channel is going to be right there when it happens. The verdict is permanent. The conviction is real. And nothing that happens in any court going forward will change what 12 people decided on that May afternoon. That is the story. That is why it matters. And that is why you should be paying attention.